I'd like to introduce the final panel, and more specifically my colleague Ryan Fritsch, counsel at the Law Commission, who is heading up our digital rights strategy, digital rights project, who will be leading this final session. Thank you.
Awesome. Thank you, Nye. And, thank you to our earlier speakers. You'll note that we've slightly mixed up the format here. This is now the coffee club portion of our meeting today. What we want to do with this panel is expand a little bit on some of the broad issues that have been introduced over the last 2 hours by taking a little bit of a deep dive into 3 specific areas of law where we're starting to see AI appear, and where our practitioners who have joined me up here on the stage are starting to engage with this in a very practical way. So we're going to look at it from 3 different perspectives, and I imagine that some of these will intersect with your own work and hopefully will be quite instructive. Each speaker will get about 10 minutes to give you their hot takes on what they're seeing and what they're facing and what they're thinking about. And then after that, we'll shift to a question and answer opportunity. So I would just remind everyone online to feel free to email us at lawcommission@lco-cdo.org with your questions, and they'll bring those questions up to me. So to my immediate left, speaking about her experiences in the criminal justice sector, are Jill Presser, a criminal defense lawyer. Next to Jill, we've got Patrick McEvenu, who is going to be talking about some of the administrative law issues that he's been working on behalf of Immigration, Refugee, and Citizenship Canada. And then to Patrick's left is Amy Terhar, who has done a lot of work on smart contracts and blockchain technologies. So thank you, all of you, for joining us. And Jill, if you want to kick it off for us.
Thank you very much, Ryan. Thanks very much to the Law Commission and to Element AI for organizing this event and for having me here today. I am a criminal defense lawyer, principally appellate, and I do a lot of work in the intersection between law and technology, principally digital privacy and digital rights. And what I'm here to talk about today for the next few minutes is litigating AI, or litigating automated decision makers, not just in the criminal justice system, but broadly. So I'm not just going to focus on criminal law related issues. I want to start by saying, before I delve into some issues around litigating AI, that I really think the better way to go with algorithmic decision makers is to legislate and regulate so that we don't need to litigate. And so, if you sense a pattern emerging from today, we're doing a lot of talking about regulating and legislating. And although I'm a litigator, I really see litigation in this area as a final resort. We reach for litigation as a fail-safe when other mechanisms for controlling deleterious effects of automated decision makers have already failed. So I wouldn't say that litigation is the tool of first resort, dealing with flawed, biased, or otherwise rights-violative automated decision makers. So really, I think it makes sense that I'm speaking later in the program. I'm here to talk about what happens when everything that the other speakers have talked about has all those mechanisms for controlling bias or problematic automated decision makers. When all of those have failed, what do we do then? And that's we end up in court in litigation. So to start, anytime novel technologies, particularly those relating to algorithmic decision makers, are integrated into the justice system, it raises complex and important questions regarding the reliability of the technology. And in my view, both the truth-seeking and the fairness imperatives of the justice system require that technological tools, especially technological tools that make decisions that can negatively impact on people's rights, should be capable of being reviewed for reliability. So in the next few minutes, I want to talk about 4 particular challenges in litigating automated decision makers that are challenges that arise when we want to make sure that people who are subject to automated decision makers can meaningfully test the reliability of those tools. And the 4 challenges I want to highlight, and kind of in passing because they didn't give me a lot of time. And those 4 challenges are, number 1, disclosure or discovery. Number 2, experts and expert evidence. Number 3, technological literacy among justice system participants. And number 4, funding. So the first litigation challenge I want to touch on is how to ensure that there's full disclosure or discovery in relation to technological tools used. And this is especially an issue in the face of assertions that are often made by developers of automated decision-making tools, is that their code is proprietary or subject to trade secret. The AI Now 2018 report, Litigating Algorithms, which I strongly commend to anybody who's thinking about the use of automated decision makers in ways that impact on justice. And I think the citation to that report and a link are in the materials that were sent out as part of the background materials for this program today. So that report by AI Now suggests that based on the US experience, procedural due process or natural justice arguments were particularly adept at dismantling claims that algorithmic decision-making tools could not be disclosed because they're proprietary trade secrets. So, for example, for automated decisions that may negatively impact on a person's life, liberty, property, or other rights, arguments arising from the basic duty of fairness may provide fertile bases for seeking orders for disclosure. So things like requirement of notice, the right to know what decision is being made and why, the right to present reasons and or evidence for why a proposed action should not be taken, and so on. These kinds of claims may all form the basis of productive arguments for disclosure of algorithmic decision-making tools. And the argument there goes that when our rights are negatively impacted, we need to know what decision was made against us, how, and or why, in order to be able to question or challenge whether the decision was made properly or whether the algorithmic tool that made the decision was flawed. And I wanted to talk about 2 kind of banner cases in the area in the States, 2 cases that kind of come to conflicting decisions about court-ordered disclosure of algorithmic code and algorithmic tools. But in the interest of time, I'm not going to address them now. Maybe afterwards at the end, if there's time, I'll circle back and talk about these 2 cases where courts in the US came to opposing decisions about disclosure. Suffice it to say that it's hoped, we don't have any case law in Canada that I'm aware of yet, where we have examples of courts ordering or not ordering disclosure of proprietary tools, intellectually property protected tools. But it's my hope that on the basis of natural justice or due process arguments, should an algorithmic decision maker make decisions negatively impacting on rights, that our courts would see fit to order disclosure or discovery of the tools at issue. And that kind of leads me into the second litigation challenge that I want to highlight for you today. And that's a challenge around ensuring appropriate expertise in the justice system. And so once a lawyer hopefully gets disclosure or discovery of an automated decision maker of a system or of code, most of us as lawyers aren't in a position to understand either the technological meaning of the system, the code, or in most cases, the legal impact or import of what we've received. And that's why being able to marshal expertise to assist us is going to be incredibly important. And then there'll be interesting questions in the justice system around admissibility of expert evidence, around algorithmic decision-making tools. And again, I commend to you, and in the interest of time, I won't say more about experts and the admissibility of expert evidence. I commend the AI Now Litigating Algorithms report, but I do just want to point to, there's one case referred to in the AI Now report where the risk assessment report generated by an algorithmic system was not, the report itself, the risk prediction report itself, was not admitted by a judge in a case involving a young person, what we used to call a young offender. The risk report itself wasn't admitted because the judge was satisfied in that case that there hadn't been rigorous enough testing of the system and of the code to satisfy the court that the report was ultimately reliable in a way that the court could be satisfied it was a good basis for depriving a young person of liberty. So that's a really interesting case, and hopefully an interesting precedent for us as we move forward into the brave new world of automated decision makers in the justice system. The third litigation challenge I want to point out is technological literacy challenges among lawyers and judges. And sort of fist and glove with that is the tendency for many, and especially I think those in the justice system, to overestimate the accuracy and meaning of scientific or technological tools. And this is a phenomenon known as automation bias. Most justice system participants don't have the technological knowledge to interpret the meaning and legal significance of technological tools, even if we get a hold of them. So even with a push to technical literacy, which I echo Carol Piovison in encouraging, by all means learn about these tools, educate yourself, acquire digital literacy. I think over time, it's, the Law Society is going to require that we acquire greater and greater technological literacy. But even with advanced technological literacy for justice system participants, we're going to need to know enough anyway as sort of a baseline threshold to be alive to when there are issues that need further inquiry, and enough to know when it's time to call in the experts. And it's going to be essential for us to call in those experts when the time comes. And this leads to the fourth litigation challenge, and that's how do we ensure that there are adequate resources to fund the experts that we need to test the reliability of automated decision makers within the justice system, and how do we fund this kind of litigation when it needs to be brought to the courts. And honestly, it's not clear where the funding is going to come from. The funding envelope doesn't exist yet, and in the wake of big budget cuts to Legal Aid Ontario recently announced by the Government of Ontario, it's pretty clear that new funding even for test cases isn't going to be coming out of the legal aid program. And in fact, speculation is running high that one of the first items on the chopping block for Legal Aid Ontario will be their test case funding program. We do know that the federal government has recently reinstated the Federal Court Challenges program to fund test case litigation that has national import. If this government survives the fall, and the Court Challenges program continues to exist, this may become a source of funding for us in the future for some of this kind of litigation. But overall, resource deficiency to challenge algorithms will mean that some communities are and will continue to be underserviced when it comes to legal representation and access to their rights, or that some communities will be subject to algorithmic decision-making that's flawed, biased, not transparent, or otherwise unfair. Thank you.
Just one follow-up question that occurs to me right off the top is, when we hosted our criminal algorithms roundtable back in March, in partnership with the International Human Rights Program at U of T, the Citizen Lab, and the Criminal Lawyers Association of Ontario, one of the really critical issues we honed in on that we're already seeing appearing in the US is this expansion of the idea of risk assessment, handing it over to an algorithm or an AI system, and then having that thing spit out what the terms and conditions of someone's bail ought to be, what the parameters of their sentencing should be, the risk of reoffending in the community. What struck me about that is that we've been dealing with risk assessments for a long time. So there's something new about this, I think, in part where we're deferring to these kinds of, or delegating authority perhaps to these kinds of algorithms. But there's something old, and that's risk assessments we've already been doing. Do we have litigation in Canada on risk assessments? And do you see any application of what we've got in case law to what we might be facing in the future?
Good question. We do have some litigation already in Canada around actuarial risk assessment tools. The tools that have been litigated so far aren't algorithmic tools, but they are statistical models created based on population, based on risk assessment across populations. So they're statistical models. And we have a decision of the Supreme Court of Canada in a case called Ewart. It's a 2018 case. And Ewart was a case, Mr. Ewart was a Métis inmate who was challenging Correction Canada's reliance on some psychological and actuarial risk assessment tools in relation to his placement within the correctional system. So whether he was an appropriate person to be placed in maximum, medium, or minimum secure facility based on an actuarial risk assessment. Mr. Ewart claimed that the validity of the tools that had been used to assess his risk when applied to Indigenous offenders hadn't been established through rigorous empirical testing. And he claimed a breach of his rights under Sections 7 and 15 of the Charter, and also a statutory breach by Corrections Canada of their obligations under the Corrections and Conditional Release Act. So the Supreme Court of Canada allowed the appeal, allowed Mr. Ewart's challenge to the use of these tools. Unfortunately, from my perspective, they didn't allow the appeal on the basis of the Section 7 and Section 15 challenges. Instead, they kind of kept the scope of their decision quite narrow, and they held that Corrections Canada had breached its statutory duties to Mr. Ewart, an Indigenous person within the correctional system. So it was sort of a limited decision, but I think an important one when we're looking at actuarial risk assessment tools, because the court there is saying we do need to make sure that these tests, if we're applying them, are empirically validated, that they're rigorously tested, and that the burden is on the party seeking to use these kinds of tools to take away rights or potentially deprived of rights. The burden is on that party to establish that the tool is valid for the purpose it's being used for. And I'll quickly mention that there are a couple of other Court of Appeal decisions considering actuarial risk assessment tools. One of them out of the Saskatchewan Court of Appeal, a case called Montgrand, Montgrand, which considered the use of actuarial risk assessment tools in the dangerous offender context. And another from our own Court of Appeal, a case called Krivicic, K-R-I-V-I-C-I-C, where our Court of Appeal was considering the use of actuarial risk assessment tools in the review board context. So for someone who'd been found NCR, to determine whether he would remain under the review board's jurisdiction, whether he continued to pose a significant threat to the safety of the public. And both of those appellate decisions stand for the proposition that these kinds of tools can be helpful, but they shouldn't be determinative. In other words, at the end of the day, the judicial job of looking at the entire universe of evidence should still be a judicial job that involves the exercise of discretion, and the actuarial risk assessment tool is but one piece of evidence that should be considered but not be determinative.
I think that's a really important point, because it brings us back to something our first speaker, Richard, pointed out, which is that at the outset of developing one of these algorithms, you got to talk about what its purpose is and think about the design of the thing, right? So if you're designing it to be determinative and conclusive, that's one thing. If you're designing it to be augmentative and supportive, that's both an opportunity to build those kinds of considerations into the design, but then also educate the people who will actually be using the tool, right? So it's sort of a two-way conversation, I think.
And what I'll say about that is, what has me concerned within the justice system is very often when actuarial risk assessment tools are used, they're considered almost determinative.
Right.
And that shouldn't be the case. They should be considered to be augmentative, and judges still have their job to do their discretion to exercise. But because of automation bias, that's often not the case.
Krevicek says we can assess risk, but you got to give people a chance once in a while.
That's right.
You got it. Fantastic, thank you. Maybe we'll move on to Patrick and hear how some of these things are playing out in the administrative law context of refugee and immigration cases.
All right, forward this on and maybe get my deck, or there we go. Okay, so hi everyone. So I'm Patrick McKevenu. I work in the policy sphere with Immigration, Refugees, and Citizenship Canada, and I'll talk about a use case we're doing and we've been piloting in our context, and in some ways, sharing some of the same concerns from the other side that Jill's raising. How do we make sure that we're not going down to litigation to solve problems, but thinking up front in our design and how to avoid those issues? Let me just set a little context about why we're going here at all. So, in immigration, what we're facing generally, Canada is just facing a huge volume increase across all lines of business. Many more people coming to the country. It's doubling every few years. This is largely in the area of travelers, right? People are just coming to visit family, to come see Canada. It's principally an area from China and India. So we're having this large volume of cases, and most of those cases are, of course, very straightforward, simple, easy cases. A few aren't, and it's sometimes hard to tell which is which. So we've been thinking about how we can use some of these technologies to help us in that decision making. At the same time, each of those decisions is very significant for the person applying. So we've been also thinking at the same time about how to do so very responsibly from the outset. So it's a few years of work that I'll describe, but it's culminating this year in the pilots that have been running for almost a year now, or a little less than that. We have been automating using AI tools. We have, in a nutshell, we have sort of looked back at our caseloads in China and in India separately, developing models for each, to automate a portion of those cases where we're looking at the past cases, 200,000 or so, looking at where do we see these patterns that emerge that show a great deal of agreement amongst our officers about what is a sort of an easy yes for the eligibility portion of the decision. There's two portions, eligibility and admissibility. Admissibility looks more at some of the security and health concerns that might come up. That's not been automated, but the portion that's eligibility is what we're looking at in this context. So we're looking for those cases at easy yeses, and we're doing that by looking at the relevant caseload that we've dealt with, which large in volume and ever increasing, as I say. Oh, let me just. How does that look? So once we've got those models in place, what it looks like now with our pilot is, as new cases come in, we're bringing them forward to the system. Some are set aside right at the outset because there are specific reasons to take a careful view of them. For instance, there's children traveling, or diplomats traveling, or there's a number of different cases that we just take off out of the mix. Then we look at the rest of the cases and use our models to figure out how do they align with these easy cases, and we divide them into groups that are from the sort of most easy or the most straightforward to the least straightforward, the most complex. We're finding about 40% of the cases line up with the most straightforward yeses, where 99.4% of officers having seen similar cases in the past say yes to these cases. In those cases, we're automating the yes. We're saying that's fine. We'll automate a yes on eligibility, and they'll only be reviewed for admissibility purposes. All the other cases fall out of the system and are reviewed by officers in the standard way they always have been. And there's a degree of QA, which we take cases that are in the yes and bring them back to officers, and inversely. So we're do a lot of checks to see, with respect to bias in our officers, how are they encountering these cases, how does that change their decision-making process, and so on. That's what we've been testing out in a nutshell. And lots of efficiency gains and so on and so forth as a result. But let me talk a little bit about what we've learned in the process. So before we did this, we put in place a portion of our act that gave broad authority for the department and its officers to make use of systems to make decisions. But broad authority, it is just one part of the equation. As we've worked through it, there's been all sorts of issues. We worked very cross sectors. I know we've had that's come up a few times, looking at how many people you have to involve in a project like this to figure it out. So of course we've delved into questions, further legal questions in terms of, as you're saying, in terms of like how we're going to produce an audit trail so that we can provide evidence of the decision-making process. How are we going to do a notice? How are we going to, which lines of business do we choose to do it at the outset? That was a question of sort of risk tolerance and other questions. What kind of do we have an officer of record in every decision? How do we do that? How do we approve these rules? How do we make sure that we're comfortable with them at a high level? How do we communicate with the public? How do we get the right talent in the department? How do we engage experts to do that kind of peer review up front to make sure that we're grounded in good science, good data science when we're with respect to our data? So there's been just lots of learning that has gone on through that process of sort of trying it out. My work and my team's work has looked at the question more from the perspective of beyond the legal foundation, what else are we going to need? What other kind of guidance does the department need as it looks at these tools? So we've worked closely with Treasury Board. We've had a couple of references already to what Treasury Board has done in terms of setting out its directive on automated decision-making. But the work started a little earlier than that. First, it started with a white paper that was done by Treasury Board and one by ourselves that worked, within the government and then within our own department to raise awareness around the issues, because it's quite clear that people don't recognize the issues that they don't recognize. They have to be made aware. So there was a whole awareness raising process that's probably a year-long process of raising awareness. And then Treasury Board has moved fairly quickly, as is described, to having a directive which provides looking at the first, maybe issue one in this case. There's lots of uses of AI, many sorts of ways that government uses it and can use it. The issue one is with respect to its use for us in decision making. So that's where Treasury Board has started, and we've started at the same time. So Treasury Board's directive provides kind of a new bottom line, I would say, to transparency and all the issues that have been raised already in terms of what are going to be the guidance to government in terms of using these tools. Our tool steps a step back from that. The purpose of the playbook we're calling now, a guidance we provide to our own department that we're working on, that we're developing right now, talks to our department about and provides guidance with respect to how we get to compliance with what Treasury Board's laid out. How do we ask ourselves those right questions and have the answers when we need them? So it comes in two parts. It's a set of guiding principles, and it's a handbook, a more sort of practical tool to guide the work. There are, in our breakdown, 12 principles. They're very seated in our own specific context in immigration, because we think it's important to translate that for people internally so they understand, well, that general issue applies to me in this particular way, and how am I going to respond? So we've tried to bring them out. There are 12. I'm not going to go over them all, of course, but it starts with a question of ensuring that we focus on a broad set of public benefit goods, not purely efficiency, which is where it often starts when you're thinking of where it started in our department. Use of this tool is about efficiency. No, it's about a lot of other things that can be achieved through the use of this tool. It starts at a very human-centered place. It's human-centered in both in terms of our clients. It's also human-centered in terms of our officers who are empowered by the Act to make decisions. So how do they use these tools? How do we get the balance right, and so on and so forth. There are others, of course, that go in, maybe some ones that are, and bias comes up in it's an inherent, it always comes up in this context. How are we going to deal with it? So there's guidance in that regard with respect to how we're going to address bias, how we're going to think about it, how we're going to look at it. And there's also a hopeful note here in the sense that these tools are also very powerful in terms of looking at bias, revealing it, and giving us access to looking at our decision making in a whole new way. For me, as a policy person, it opens a whole new vista of policy work where I can really dig in a way that I don't know if we ever could before in terms of how fair those decisions are being made, how fair they are. Also raising questions around access, the access to recourse mechanisms. I think it's an interesting question. I'll be interested to hear what the audience is saying, hearing what Jill is saying about what this is going to mean in the future. At this point, we're really dealing with only positive decisions. So there's a little bit of a less of a worry about heading to litigation, still possible, but we're thinking forward. So that's a very interesting question for me to think about, to hear about. The next part of the playbook really focuses on, it turns those principles into questions for our developing teams and asks, have you thought through this, have you thought through this? And tries to lead them through in a fairly linear way. So when you're thinking about even taking on designing or thinking of this idea through at the idea stage, when you're about to design, when you're about to launch, and as you go forward, it's been launched, now you're running, what other questions? So it tries to lead them through those, ask the questions up front and tell you when you're going to need your answers for, to help make sure that we cover the basis. Thank you. So we're hoping that this guidebook will be out in June and summer, but June, in fact. We're in fact hoping that we'll be able to bring it out at Metropolis, our International Metropolis conference that's coming up at the end of June, and we'll have a chance to sit on a panel. I will with Petra Molnar from Citizen Lab, who I've been on a panel a number of times with her, but to sort of talk about what the dangers are specific to AI in its context of immigration, really interesting set of topics, and how we think of where we are globally, and what Canada's response is like, and how do we grade Canada's response thus far. So it's one that we've been engaged with, we're very interested in that discussion, and I'm very interested to hear what people will say today, and as it comes out, to make it public so that people can provide us their input as all along.
Terrific, thank you. One of my follow-up questions leads off what you just mentioned, which is the particular challenge of AI in an immigration, refugee, and citizenship context. I noticed that the first step on that rubric you had on the previous slide, asked us to take consideration of the impact of these systems on our clients. Is there a role for the clients to help you define what those impacts are? And I'm thinking back to the design phase here, and I'm thinking back as well to your specific context of cultural differences, linguistic differences, different views of what a family is. Questions that might on the face of it appear to be quite neutral can be quite loaded depending on who you're talking to. So talk to me a little bit about how clients might be involved in the design process of these things.
Yeah, it's an interesting question. I mean, I think that client-centeredness is, it's a long-standing trope within the government, but it's very significant in the last few years, let's say. We've had a very significant turn towards client-centeredness. We've created a client experience branch, and that really focuses on engaging clients and getting to understand the design approach from their perspective, how they're experiencing the approaches we're using. So I think there is sort of increasing ability for government to go out. There's been, it's not always easy to talk about that technology when we're in the testing phase, and it's been I would say it's a struggle from internal, just candidly, as to know when do you go out, when do you not, as a government, when are you going to raise fears, and when are you going to be able to enough to kind of really have a discussion. I think we're at that place now, and so the test that, the piloting that's gone on right now is very much restricted. It's only within a very specific line of business, and only a portion of that line of business, travelers from 2 countries. There's no plans yet really about where we're going next, but when we go next, I think that's the salient point. Right? How do we engage our clients along the way, and how do we engage the wider community in this? Because we had to bring Canadians along with the government's use of this. Yeah. We're really sort of thinking now a lot about how we get that sort of social buy-in on what government's use is going to be, and where the comfort level is. And so that's something we're thinking a lot about.
And is that one of the factors that the Treasury Board Secretariat's directive looks at, or is it one of the factors your playbook anticipates?
In transparency, only in the context of transparency. So the Treasury Board directive really thinks about what you've done by the time you get to the end of the process a little bit more. We are trying to move it up to things, so when you get into the design stage. But yeah, that's an interesting question. So we've been thinking about transparency mostly as once you've got the thing designed, how do you provide people notice that they're subject to it? How do you give them access to it so they understand what's going on? Yeah. And we're always, again, balancing program integrity concerns and so on. So you're giving me something to reflect on, though. I think wondering when are we going to get to that? When do we do that transparency? Is it only at the end product or the design stage? Interesting question.
I think one of the other concerns people generally have is that they sort of say the tip of the iceberg is a slippery slope. So you've now got this algorithmic product you've developed and are deploying. What's next that you might be contemplating, and do you see any no-go zones where that level of risk is just too high?
Yeah. So far in our approach, we haven't identified no-go zones specifically, like a no-go program or a no-go client or something. But we are urging caution, and as you say, the first question is, what's the impact on your clients? What's the context in which you're operating? many contexts that, like the refugee context, exceedingly complex, exceedingly fact-driven, exceedingly sensitive, not one you're likely to see early on. Now, not every part of the refugee context is like that. So there's also questions about where do we set our officers around, how do we deploy equipment, there's a lot of questions we can use AI to help us solve that aren't decision making. So you have to think of the technology of course broadly, and we think of it that way. Next, I can't say for sure, but because we don't have the plans for next, and we do have an election coming, which may change next. But I do think that the next, because of where the volumes are, and that's principal driver, a next big place to go is just to get more people into the lines, to get more of the lines of business connected to just travelers in China. More of them are using electronic applications, which are the ones we're automating. So there's just more driving the business into those places where we can use this tool. Already produces significant gains for us. So these other complex questions can be left. There's not such a push on some of these more complex questions. So we haven't got the discussion going on in the citizenship context, nor in the refugee context, nor in the permanent resident context. It's really focused where our problems are right now, which is managing volumes in the TR world.
Okay. Good stuff. Yeah. Thank you. Amy, one of the things we heard a lot about earlier today was approaches to self-regulation. And I think contracts are probably a big part of that. So why don't you tell us what's going on with AI and contracts these days?
Yeah, absolutely. And I'm so glad to follow this because it really highlights that it all comes back to the governance of these systems and their design and their architecture and their deployment. And again, highlights the importance not just of the regulation and the design from the governance perspective, but also how this impacts the business models going forward. And what I want to do this afternoon, really quickly because we're really short, but just open your mind to the possibilities of what tech enables and bringing together business and law and technology to open up those new realms of possibility. And I want to give you one example just to continue on this, looking at AI systems that enable you to predict outcomes and detect threats. And marry that with a blockchain, because out of that arises this new possibility of these self-executing agreements or smart contracts. And I'll just really quickly touch on, for those of you who aren't familiar in the room with blockchain and what smart contracts are, to go through that so you can sort of contextualize what is possible, what's happening, and what will soon be a reality within the legal profession, both on the litigation, the governance side, and from a business model, legal services delivery, project management side. One of the best examples that's coming out of Toronto that I see, and I'm a big evangelist for the Canadian approach that they're pioneering, is SecureKey, who has come out with a new application called verified.me, and it's based on blockchain. And what it enables verification and authentication of identity. And what it represents is not just identity, but a system that enables people to share their personal data in a way that benefits them, identity credentials just being one piece of that. So where you have in the legal profession, this old way of identifying client, bring in a plastic card, which any 16-year-old can go and get for $35, and using that as the basis of authenticating identity just is really inefficient, insecure, and vulnerable. And what you can do now with technology is based on blockchain, which we'll get to in just a moment, is to use this triple blind approach. So you have a more secure system for people to enable the sharing of their own personal data in a way that doesn't breach solicitor-client privilege, and that where each relying party doesn't have access to an unencrypted form of the identifying information or data to begin with. And so that's actually what's possible today. And that's just on identity. And we haven't even started talking about smart contracts and blockchains. And while blockchains aren't predicated on the use of AI, what they do is really enable these new types of business models and processes to be realized in legal services delivery. And so, what you see from a market perspective is this response to this pain point, one of the most critical pain points being that everybody hates contracts, or, you know, in much the same way that we're relying on, you know, old-fashioned systems to verify identity and use credentials, you know, insecure credentials to do that. Contracts represent the same thing. They're insecure, they're inefficient, and they're vulnerable to all kinds of attacks, and most importantly, they can't communicate with each other. And so by implementing blockchain, and blockchain is a system that, and it's a distributed ledger system that, you know, enables people to do two things: to easily ensure that information hasn't been tampered with, and to keep secrets. And it uses fancy math to do that. So imagine a game of Connect 4. You know, everybody has their own little playing platform, and, you know, imagine the little tokens, little pieces you drop in to play the game as your data, and everybody can play this game. Instead of 4 people, imagine there's like 1,000 people playing this same game, and by playing your own chip during your own turn, you can see what everybody else is doing. You know, when it's your turn, you can easily verify, you know, the state of play as at a particular point in time, because there's transparency around who's playing and what they can see happening in real time. And blockchain is sort of a similar way. It's distributed, meaning that it's peer-to-peer. People can have reliance on this single version of the truth that's distributed. So everybody has a shared system of truth, rather than relying on a referee to say, you know, it's your turn now, you should play now, or the score is, well, there's no score in Connect 4, I guess. But if there was a score, you'd all be able to see, you know, there is, I guess when you reach 4, you'd be able to see, okay, so player X won the game. Similar to that. And what that enables from a connected conscious contracting perspective is a whole new realm of possibility, integrating that, of course, with AI systems in the background. So imagine this new approach to sort of like air traffic control of contract performance management, or contract management in itself. So the result being that you get these smarter contracts, and smart contracts, if you've heard them, relying on blockchain, they're neither smart nor are they actually contracts. They're just, you know, self-executing pieces of code. So it's bringing, you know, the software code together with data, enabling, you know, an if-then scenario to be programmed right into a legal agreement, which of course needs to have, you know, the requisite characteristics of a typical contract as designed in the jurisdiction in which that contract would self-execute, as you will. But what happens is, the reason this all comes back to the governance and the ethics and the design and the architecture, how you design that, is because, you know, these types of systems operate extra-jurisdictionally. No, they're not limited by jurisdiction, and so there needs to be, you know, this. You know, I always say multi-stakeholder, but I heard multilateral bringing together of different parties to design these types of governance systems. Because what happens when you move along this, you know, cross-stakeholder decentralization from public types of blockchains to, you know, permissioned private blockchains, you need this whole new set of house rules to enable those business processes to work in a way that ensures the transparency and the lack of bias that we've been talking about today. And so it's really, really, really important. Malta, for example, just you know, this summer we'll be implementing legislation to the effect that, you know, distributed applications can act as autonomous agents and be defined legally as such. And so what happens when you start to move that outside of your own jurisdiction and rely on other jurisdictions? You've got this, you know, jurisdiction shopping, much as we see with the crypto realm. In Crypto Valley and Switzerland and Malta and Asia and Singapore. And so you've got this whole new world that is like upon us. It is not, you know, it is now and it's happening. So I think, but it's so important that we, you know, from a governance and ethics and architecting, you know, what that looks like for different types of permission and private systems and AI deployments. It's really, really important.
Yeah, that's amazing.
Yeah, I can go on, but I'll just let it sit there for a minute.
One of the examples I just came across about the use of a smart contract blockchain to address sort of this regulatory gap just came out of the healthcare sector. And Stanford is now experimenting with a system that basically keeps all your data in a blockchain chip in their cloud system, all right? And then to train the machine learning algorithm on that data, they upload the algorithm to that system. It does its thing on the data that's held there, and then they sort of offload the algorithm, right? So the data never moves. The data is never transferred, right? What does happen, though, is that the data through the blockchain recognizes that this algorithm is trying to access it, and it self-executes. It triggers the notice to the data owner, i.e. the patient, and says, do you consent now to this particular algorithm to use your data to do its machine learning thing, and here's the conditions under which the data will be used, right? So that's kind of like the self-executing piece, sending the trigger back to the owner of the data, the patient, to authorize its use. I'm thinking about this as a regulatory tool. That's a rudimentary example maybe, but can you bake regulation into this technology? And is that part of what the promise of this technology holds for managing some of these concerns with regard to AI?
Absolutely.
Absolutely.
And totally. And again, it comes back to so if you're storing, your data on this piece of hardware and distributing it on a blockchain, firstly, blockchain is great because you can distribute, you don't have the single point of failure that you would, for example, storing it in a hardware chip, but by having this federated model, putting the protocol into the data rather than extracting the data and putting it into a machine that's running the protocol, right? It's just a much safer way. And by having, a set of, I love baking, as soon as you start to tokenize these digital assets of value that have uniqueness, much as health data and patient records can have, you can tokenize that. And then when you tokenize it into that token, you can bake the governance of, how the data is permissioned to be shared. And for example, this example that I said with secure key and verified.me, having this triple blind approach is precisely that, is using, sharing information from Equifax, from the banks, from your telco to have this trilateral verification. You are who you say you are, and being able to tokenize that and hash it in a secure way, and have that governance baked right into that smart contract or piece of software code and connect it with the data. And that's precisely it's such a great use case. Yeah. So yes.
Awesome.
Yeah.
All right. Good stuff. We're just about at time, but if you'll give us the indulgence, we'll go a couple minutes longer and open it up to any questions from the floor, if there are any for any of our speakers here. No? All right. Any questions online?
Yeah, there's a question online for Jill and for Patrick, which is how can AI be of assistance to self-represented litigants if we see, legal aid withdrawing, if we see more self-reps in all different contexts in our justice system? How can AI be of assistance to people who may have to fend for themselves for the benefit of counsel or some form of legal professional?
There are some experiments with access to justice, algorithmic tools to make justice more accessible in a number of different spheres and places. There are people who are very expert in this. I am not one of them. But I know that there are tools being developed, sort of public-facing tools being developed to assist, for example, self-represented litigants who aren't able to retain counsel and who aren't qualifying for legal aid in the face of cutbacks, to navigate the justice system and to, do their court filings with the assistance of some tools. I can't give more information than that, unfortunately.
Yeah, I don't know. I don't know if I have much to add on this. It sort of goes beyond my expertise. I do think it's a very interesting question. I know that there's been some interest in the government in looking at the degree to which AI can be used effectively to help litigation management, to help as a litigation support tool. That might work for us. How it would work when you don't have experts interpreting the results of such a thing, lawyers, and make use of it, I'm not certain it would work. So, that sounds like a very interesting project, but not one that I would be, I think it would be a significant design sort of undertaking to make use of it. You're not going to replace a lawyer simply with AI in any quick way. interesting, cautious.
Well, I think one interesting angle on this is a little bit of a wider step back to some of those due process considerations, not just about self-represented litigants, but equitable access to the tools that some litigators are using and others may not have access to. A really clear example of that I'm aware of is apparently the Canadian Revenue Agency is now using some kind of AI tool to in part help them determine some questions of employment. When is a person an employee? When are they a contractor? When are they self-employed? They're apparently using this to help guide their decisions, I guess, about how to process a claim and probably litigate or audit ones that they may disagree with. If they use that tool, what a right of access does the respondent have to use that tool and to put their own characterization of the issue into that tool and see what answer they get? And then what do you do with that? If the CRA gets a confidence interval of 80%, what if I put my spin on it and I get an 85%? Who wins? How are we going to adjudicate that? So there's an aspect of this which is new, and if these tools are going to be deployed, we have to ask ourselves in part, what's equitable access to these tools going to be, and where and when do we deploy that, and how do we support it? I think is a really important question.
A lot of this is happening in alternative dispute resolution.
Sure.
Right? The BC civil resolution, somebody help me out, civil resolution tribunal?
Is that condo authority thing?
Yes.
Yeah.
I mean, it's not particularly AI, but it's another great use of technology in enabling access to justice.
Yeah, for sure. Yeah. All right. Any other questions from the floor? Okay. Well, thank you to each of you. It was a tremendous discussion and a lot to take away and think about. So thanks very much.